Hello, and welcome to Unpublished Opinions, the Institute for Justice Roundtable podcast where IJ attorneys get together and share their unvarnished and unpublished opinions. I'm John Wrench, your host, the Assistant Director of the Center for Judicial Engagement at the Institute for Justice. We're recording from our studio in Arlington, Virginia, where it is a beautiful sunny day, and I am joined by two of my lovely colleagues, senior attorneys Sam Gedge and Josh Windham. Thank you, Sam and Josh, for being on.
Thank you, John.
My privilege.
So something that you both share in common that I'd like to ask you about in kind of a different angle is you both have experience working with either legal doctrines that kind of haven't been used in a long time, where you have to kind of like dredge them up and kind of pick them up and use them as a tool where they've been ignored, or you have to deal with challenging old, like really bad legal doctrines that have sat around for a long time, and for some reason no one has really touched them. So just for a little bit of context, Sam, you worked on Timms versus Indiana, the IJ case where you successfully asked the U.S. Supreme Court to incorporate or apply the excessive fines clause against the states, which is a big deal, and it's might be shocking to people to hear that the excessive fines clause hadn't been incorporated and just been sitting there as a very powerful tool for a long time. And then Josh, you've spearheaded our open fields litigation, where you've been asking state courts to reject the federal Fourth Amendment open fields doctrine, which basically is that if you're going on people's private property, even though it's posted or fenced, it doesn't implicate the Fourth Amendment. And so that doctrine has been around since like 1923, right? And so it's sat around for a long time and no one has really challenged it. And so I'm curious about why do you think it is that these either very powerful legal tools sit around for so long without being used, or these really bad doctrines sit around for so long without being challenged?
I have a few thoughts on that. So I think, first of all, the winning arguments in private for-profit practice are typically not the untested, archaic, let's try to dust off the old books and revive this ancient rule arguments. They're the ones that are like tried and true, well-tested, well-trod. I mean, it's economically risky for a client to pay for arguments that are effectively untested or even foreclosed by precedent. In public interest law, I think there's a few things that can impact this. So some of it's just timing, right? So you had I think it was 1833 at Barrett versus Baltimore, where the Supreme Court says that the Federal Bill of Rights, doesn't apply to the states. It only binds the federal government. And so there wasn't really going to be much development of federal claims in state action cases for that period of time. Then you had incorporation after the Civil War, and so parts of the Bill of Rights started to be incorporated against the states. And at that point, I think you had this sort of pendulum swing back where federal claims start to dominate, and so maybe state constitutional claims fall by the wayside. So there's just kind of timing issues with periods of time when certain types of claims would have been more or less, prevalent. And then I think also there's just this question of are today's lawyers more sophisticated or more creative than past lawyers? I think the answer to that is no. Mm-hmm. I certainly feel less creative than lawyers of decades past. I think we just have better legal research tools, right? We can unearth history that maybe they didn't have access to decades ago, private papers, that kind of thing. So we just have more information at our fingertips than lawyers of past generations did.
Yeah, that's true. On that last point, I agree. I don't think that we're better lawyers than John Adams and his ilk.
You guys are very humble.
Yeah, that's why we're on here. I'm sure. I'm very, very personable. At least Josh is. But I mean, I feel like in more recent decades, there's been an increase in specialization and professionalization of a lot of lawyers, and for better or for worse. I think there's a ton of value to having generalists and generalist judges. But the advent of the U.S. Supreme Court bar, that's only really come about in the past maybe 20 years, maybe a little bit longer. And before then, as I understand it, for much of our nation's history, the folks arguing in front of the U.S. Supreme Court, if it's a case out of Wichita, Kansas, it's a couple of guys from Wichita, Kansas, who I'm sure are great lawyers. But if you go back and read briefs even in the 70s and 80s, even from the Solicitor General's office sometimes back then, there seems to be not as much of a depth of analysis. To Josh's point, the research may be not as sophisticated as we're able to do kind of with a click of a button now. And so that I think may be partly why some of these issues have really not come to the fore until more recently.
If you're a listener to Bound by Oath, one of IJ's other podcasts. The episode about open fields last season called Mr. Thornton's Woods kind of dug into the companion case to the Oliver decision from 1984, the open fields case. And that case was called Maine versus Thornton, and they were combined at the SCOTUS level. But we went to go visit with the Thorntons because they're still around, the property's still there. And we kind of walked the land and got a sense of, where the officers went and how it all went down. And one thing we learned from them when we were there was the lawyer who represented them all the way up to SCOTUS from the original motion to suppress in the trial court was just like a friend, like who just worked down the street. And it was a buddy, right? And it's like, that would be kind of cool if that happened more today, right? But it seems like the SCOTUS bar is sort of this elite class of people, and you can kind of predict the names that are going to be in and out year after year.
Yeah. There was a case, I think, that rhymes with that the last term or this past term, one of those Facebook blocking cases out of Minnesota or someplace like that. And the lawyer there, I think, had just been like longtime friends with the city manager of this small town who's had like blocked some troll on the internet. Yes, indeed. Although I shouldn't say they're a troll. Apparently they're quite litigious. Their case went all the way to the Supreme Court.
Trolls can be litigious.
Indeed. But I'm sure that everyone's operating in very good faith in that case. But in any event, yeah, they were just buddies, and the client, the city manager, kept her along even once it got to the Supreme Court, and presumably he had lots of high power, big names banging down his door.
I mean, I did say it would be nice to see more of that today, but I don't actually know what I think about that. I mean, what's your take, Sam? If I had to put you to a wall and say, hey, give me your take on should there be more or less people arguing before SCOTUS who are sort of like not big names?
Yeah, I mean, first I'd correct you that you should have said more or fewer people.
Okay, thank you.
But having done that, and
so glad you're here.
endeared myself to all listeners. I don't know. I guess I think there are a lot of excellent lawyers who would do an excellent job at the U.S. Supreme Court who are not getting that opportunity, and I think that is not a good thing. But there are also cases every term where the people who are arguing it seem like they might not have been prepared as well as they should have been. So I guess I'm charting a middle course on that.
Very diplomatic answer.
Yeah. Do you
there should be more Sam Gedges at the Supreme Court. Let's be clear.
Well, we can all get behind that. Yeah.
Yeah, I mean, that seems like this specialization is especially true now that it seems like each area of constitutional doctrine just gets like more and more complex, and it is hard to imagine someone being an expert in, like truly an expert in 5 or 6 different areas of constitutional litigation. I know that those people exist, and plenty of them are IJ attorneys, but it just seems so difficult, especially back then, not having access to that. I cannot imagine doing legal research without the kind of legal databases that we use, and even those are getting better and better. So that seems like a plausible explanation for it, and also like the rise in public interest, like impact litigation, also probably is, it's relatively recent. There was constitutional rights before there were established public interest law firms doing impact litigation, and it's just such a different way of looking at the law. Because I imagine for plenty of people with like the open fields doctrine, like what did people think after those decisions? Was their view of it like, this is settled law and I guess we're going to have to learn to deal with it, or was it like, I know that there is some public interest law firm out there who I can go and find, and they'll fight this case. They're going to go on a this kind of crusade against this issue for years and years. And I imagine most people just didn't have that option.
There was a point that, not to cross podcast reference here, but there was a point that Sarah Isker made on Advisory Opinions relatively recently about kind of this topic and the issue of people who are mired in maybe one issue and who specialize in that issue throughout their careers perhaps being less prepared at SCOTUS, because there's a lot of more generalists at SCOTUS who are capable of kind of riffing on areas of the law that's not the issue in the case, but the question is how that area of the law integrates with the kind of broader sweep of the law that SCOTUS has to deal with. And I don't know what I think of that. It maybe depends on the case. I will say that if there's ever a situation where the court needs to appoint an amicus to argue about the open fields doctrine, I would hope it chooses me. So, I mean, I think specialists can play a role depending on the type of case, but I'm not really sure what I think about the overall proposition of are generalists better at SCOTUS arguments than specialists?
I mean, if you listen to the next episode of Advisor Opinions, our colleague Kirby Thomas West submitted a very lengthy email on that very topic, which was discussed at length.
Excellent.
And I think that she was pro public interest firms.
Okay.
You'll be surprised.
Surprising.
Here, Kirby, I'll have to go listen.
Yeah.
Yeah, I also wonder, and Sam, maybe you have a better idea of this, at least in the excessive fines context, but I imagine that the pressures, there's also sometimes probably external pressures to go find a tool to deal with an issue that's becoming more and more of a problem. Like increased use of fines and fees suddenly makes something like the excessive fines clause like a shield that you need to go find quickly. You're looking for any avenue to kind of deal with them, and maybe once they were before they were as commonly used as they are now, there wasn't as much pressure. Do you think that was also something that influenced that?
It's not your worst idea, John.
Thanks.
I think there's a lot to be said to that, actually. And so on excessive fines in particular, that actually seems like it might be sound, because I think the excessive fines clause does its most urgent work in cases that don't actually involve classic pecuniary court-imposed fines in criminal cases. Because typically in those cases, the judge is exercising a lot of case-specific discretion to ensure that they're imposing a fine that they think is matched to the offender's ability to pay and the gravity of their particular offense, in the same way that they're setting aside mandatory minimums, in the same way that they're imposing all of the rest of the punishment in that sentence with an eye towards the specific defendant. Those kind of case-specific analyses, I think, oftentimes do a lot of the work that you'd see the excessive fines clause doing. They're ensuring that the penalty is not constitutionally excessive. But with the astronomical growth of forfeiture starting in the 1980s, for example, with the growth of civil penalties that are determined by executive branch agencies, again, around the 70s and the 80s, a lot of the power to be making the decision of what property is getting taken and no longer is resting with a judge who's making that decision based on all the facts and circumstances. Instead, it's resting with the prosecutor who decides whether to kind of flip the on-off switch for a forfeiture, where like the car is getting forfeited regardless of whether it's $500,000 or $20,000, or it rests with the IRS or various other agencies. And in those circumstances, I think there's a reason why you're seeing the excessive fines clause starting to get a lot more action.
It makes a lot of sense. Yeah, I mean, it's interesting that in those situations where there's either a legal tool that hasn't really been fleshed out or put to use, or there's like an old bad doctrine that no one's really challenged, it seems like, especially if they've been settled or untouched for so long, there's like a lot of doctrine that gets built around them, right? So you have like all this doctrine about curtilage, and all of this is probably interrelated with open fields, and it's like, how would that doctrine have been shaped if open fields wasn't a doctrine? And it's kind of similarly with excessive fines. You might expect that maybe excessive fines and cruel and unusual punishments would have taken kind of totally different routes and developed in different ways. But right now, at least, it seems like people are still trying to untangle them a little bit.
Yes.
So I saw this tweet. I'm actually not sure what it's called. Is X's Zeets, I've heard.
Oh, no.
Posts. Post is just very boring. I feel like tweet was the platonic form of what you'd want to call it. But it was a Zeet or an X or a post, I think from last week. This is Professor Oren Kerr, and he said, I'm going to read this, rule of thumb, a law review article written after a major political dispute has arisen, when everyone knows a big case is coming and can see what use scholarship on a particular side is likely to play in the case, is functionally an amicus brief, not a law review article. Do you have any thoughts on that? Do you think that that's right? Do you think that that's wrong?
I think he's creating a false dichotomy. Like well, the sort of premise hidden in the statement there is that we should be skeptical of strategically timed amicus briefs because they're designed to persuade, and perhaps law review articles are, in some kind of disinterested ivory tower where they're not interested in the impacts of their work. They're just interested in the truth. The court's job is to get the truth, right? The court's job is to get the law right or say what the law is. And the court doesn't have trouble doing that, presumably, when parties before it make advocacy arguments and persuasive points and gun for their preferred outcomes. I don't see why you would write a law review article if you thought it would be practically useless to write it. Like, the point of writing anything is to have some impact on the world if you're in the legal space, right? So I don't really grasp why we should be skeptical of somebody writing a law review article that is designed to persuade if they think the content of the article is true, right? I mean, there's maybe a separate question of if you are lying through your teeth or if you're abusing the title of law review article. We should be skeptical of that, but same could be true of legal briefs too, right? So I'm not sure that I see the neat divide Professor Kerr is kind of like trying to draw here.
I think I mainly agree with that, and maybe to put it a slightly different way. I think he's right in the sense that, if a law review article drops on a hot button topic, presumably the person writing it is writing it because they know this is a hot button topic and they want to get cited in a court opinion, because I think that's something that law professors like. But I think that's almost certainly equally true of lots of other law review articles, right? Like if we're talking about someone writing a doctrinal law review article, they're like the brass ring for them, I think, is having that article be useful and persuasive and be cited by litigators and be cited by courts. And it seems to me that to the extent someone's kind of just like hopping on to the next, shiny issue, it may be a difference in degree, but not in kind from what a lot of other law professors are doing. It's not to say, I guess, maybe the way I would think about it is, like, maybe we should just be skeptical of all of them, right? Like, I don't know that when I'm looking at law review articles, I feel like if I recognize the name of the professor, I know they're an expert in a particular field, I'll, come in with like a presumption like, oh, this is worth taking seriously. If I've never heard of the person, will look forward to reading it, but I don't kind of give as much weight to it necessarily unless it comes across as persuasive. And I just don't see why that's different if it comes on a hot button topic at a certain time. If it's garbage scholarship, it's garbage scholarship. And there's
I almost question an author more if they're writing in a vacuum for no reason, right? Like if you're just somebody who has decided, I'm a law professor, here's my intellectual hobby horse, I'm just going to grind away at this for years and just spin logical circles on white paper, and who knows if people will cite that or read it, but I'm just going to really crank away at that for years, and that's going to be my one esoteric issue. Like, why should I trust that person's judgment or opinion more than somebody who sees a real issue in the real world and wants to make an impact on that because they think they know the truth?
Well, and the related point of this too is that, a lot of these law professors who write law review articles about something that they think they know about oftentimes are actually filing amicus briefs in these cases saying the same stuff. And it's just like, it just seems like there's a qualitative difference, I think, between law review scholarship and like scholarship in like STEM fields, right? Like one, there's peer review in these other fields. And two, law review articles are just people saying what they think the rules should be that govern our society, right? It's not like really provably correct or incorrect in like the same objective terms that you would see in scientific scholarship. So I don't know. I mean, I guess I share Wherein Kerr's views. I would just kind of extend that skepticism to the entire enterprise of writing law review articles.
Yeah, and not to dunk too much on the tweet or the X or whatever you want to call it, but okay, that's fine. I mean, I don't get the point. So if it's okay to write a law review article that you want to be cited by the Supreme Court.
No, you don't. I think you should want it not to be cited. You're just writing it. I think it's a passion project.
You shouldn't care one way or the other.
My read on this is something like, I think the charitable read on this is something like, it is more a law review article that is written as a kind of a passion project that's not about something that's upcoming, is more likely to be a result of actual scholarship than something that is written about an upcoming issue. And it also, I think this is what you guys have been saying about this distinction that might not really be there, is that plenty of law review articles are written about things that are upcoming. Maybe it's not like a cert grant, but it's an issue that's percolating. It's been percolating for years, and you know that it's eventually the court's going to have to address it, and you have time to write an article. It just seems to reflect this idea that law review articles are this necessarily scholarly thing, and amicus briefs are not. They're just like a cite me, and that just I'm not sure that I buy that very much.
I mean, it seems like the real concern that's animating this, and I mean, I don't know if we're allowed to say this out loud, John, you're the host, but like this is all about the birthright citizenship kerfuffle,
absolutely,
right? So we can just like kind of acknowledge that.
Yep.
But it seems like what the real kind of animating concern about this is not so much that law professors are out there saying things in the world, but that kind of these like unsound documents that are just like methodologically just wrong or untested are just going to be used by judges to actually affect the way that we are governed in real life and have real impacts on real people, and that judges will use this unsound scholarship as a fig leaf or a cover for actual bad rulings. And if that's the concern, it's like, well, we should probably be a lot more concerned about the judges than about the law professors who are kind of off pontificating about their things right or wrong. But it also just, it seems to be like there too, the concern really just seems to be not so much the timing or the motives as the fact that people, rightly or wrongly, I'm not a birthright citizenship expert, people seem to think that some of these late-breaking articles are just junk science, basically. And I don't know if that's true or not, but that seems to be the concern, right? And if we can compare this, right, with the Section 3, the 14th Amendment Section 3 article that Will Bode published a couple of years ago, which likewise, I don't think it came after the litigation over Section 3, but it was like around the same time. It's a percolating hot button legal issue. And rightly, I don't think there was anyone that I'm aware of saying, he's just kind of trying to write a fake amicus brief and, turn the Supreme Court one way or another. People kind of took it on its own terms, and people found it to be quite persuasive because Will Bode is a very smart guy. And so it really seems like the concern here is just like, some of this stuff just apparently is wrong. And there's a lot of bad scholarship out there, and it's not great if Supreme Court justices or other judges are relying on it.
Yeah. I think if you read that tweet as something like cautioning against people looking at this kind of scholarship as an indication of someone's career where they've been thinking about this issue, and so this is a result of that. But that all just, I think, goes to whether the article is persuasive or not. Like, is it reliable? Is it honest? And I think that's something, that judges are going to look at.
And just to say one more thing about this, I mean, I think I'm more, like I said earlier, I think I'm more skeptical of somebody who has spent their career dedicated to a specific idea, and so their views are entrenched. Like, they're not intellectually nimble on some of this stuff, and so they're going to say what they're going to say, regardless of perhaps issues in the particular case that's causing people to become interested in this particular topic, informing or directing the way they think about the issue. One way to put this is I'm more skeptical of ideas that purport to be divorced from reality than ideas that are tailored towards reality.
Yeah, that siloing in expertise is an interesting point, because there are certainly amicus briefs by professors or organizations that I think when you see them filed, like, you can guess the contents, I think, generally speaking. Even though you probably shouldn't be able to. You at least should be able to expect that there's probably some objective thinking there. But yeah, it seems to be not an issue with law review articles or amicus briefs, and maybe just like what someone is doing in those documents. So, speaking of other things that may be good ideas or bad ideas, Sam, I know that you have thoughts about footnotes, and specifically footnotes in briefs.
I guess I do. That was an impeccable pivot, John.
Thank you.
Very nicely done.
Very Sanders-esque of you.
Oh, thank you. Yeah. Shout out to Anthony.
Yes. So I noticed it must have been on, I don't actually have an X account or a Blue Sky account, but I saw it somewhere on the internet, someone pointing out
How do you know if it's real?
I noticed that when you sent us that screenshot, I was like, this is from an unlogged in account, and this is Sam signaling to us that he doesn't have an account.
I guess I was, though, unintentionally.
I read a news article that linked me to something that had a screenshot.
Precisely. I'm very old school when it comes to my news. Anyway, apparently Chief Judge Boasberg of the DDC has been doing a lot of things the past month or so. The most noteworthy, though, is that he is standing by his very firm aversion to the overuse of footnotes in briefs. And I don't have it in front of me. No one printed out the tweet for me to look at, or the Blue Sky post for me to look at in hard copy. But apparently he or maybe the district as a whole just has some rule that basically says, you can only have so many lines of footnotes in your brief, and that can only be some percentage of the number of pages. And he will just like strike your motions, strike your briefs if they have too many footnotes. And I mean, I don't. kind of contrary to your suggestion, John, I don't actually have super strong views about this, but I will say, like, I at least try to minimize footnotes in briefs. If I can write a brief without any footnotes, that's just great. Even more satisfying is sometimes the one footnote, which you can then use a little star as an asterisk instead of a number. That's nice. Real treat. But
it's a power move.
It is.
Yeah. Judge Wilkinson in one of those Alien Enemy Act cases.
One of the recent ones, yeah.
Star footnote. Yep.
Very powerful.
Yeah, very powerful indeed. But yeah, I mean, I actually don't really have like super any really thoughts about it. I just thought it was kind of noteworthy.
Well, I did actually look to see because of your post. It does look like there is a district rule against excessive footnotes. And it's not exactly clear what excessive footnotes mean. Though I think...
is there decisional law on...
So I looked.
Excessiveness
I looked
of
and I
footnotes?
didn't find anything.
Oh, I think Chief Judge Boasberg may have just like be single-handedly creating precedent.
Yeah, I mean, someone's got to do it. You know, you have to define excessiveness, as you know, litigating excessive fines clause stuff. It's a bit of a... it's a hard word to pin down, but
some of us would disagree, but that's neither here nor there. I mean, I do wonder if the concern is people trying to evade page limits, in which case the answer is let's just switch to the appellate practice of having word limits instead, which make a lot more sense, not least because it would reduce the incentive for people to use the Garamond font, which is unspeakable, but does give you more room on pages, as you know.
Can I ask you a question about this? Is the Garamond font unspeakable because of the italics or because of the font itself?
I think both. Yeah, I mean, the italics, I think, compound the problem. That's unreadable. But I think the reason you can fit more of the words on the page, and doubtless you have font scholars listening to this.
Oh, of course, we have
John.
many.
They can weigh in.
Yep, I'm sure we'll get a bunch of letters.
Yeah,
in different fonts.
Yes, indeed. When wingdings. I think the reason why one of the reasons it's so unreadable, I think, is why the same reason if you can fit so many words on the page is like the text is just narrower and harder to read. And,
Josh, do you like Garamond? That sounded like a Garamond-friendly question.
I used to use it. I've gotten away from using it.
Are we all equity people?
Sam is a holdout, I think.
So I've started using equity in certain contexts. I like centric.
Is that because you like the style, the look of my briefs?
Yeah, I think you actually inspired me to. Well, because Josh sent me a Word document of one of his briefs in equity, and I did not have equity, and so it looked awful, which spurred me to ask our colleague Kendall to send me the equity packet, and I haven't looked back.
Yes, it does look awful when you receive something when you don't have the font installed.
I sent a draft of a North Carolina Supreme Court brief to our colleague Renee Flaherty like a year or two ago. I forget exactly when I sent it, and she didn't have equity when I sent it, and she was like, "Why would you do this?
Lost your
like,
mind.
what's wrong with you?"
It comes in like Arial font or something. Yeah.
I said, Renee, how could you possibly think I would do that? You have to know that I would do better than this. Anyway, I'm losing my train of thought. But on the Garamond question, I mean, I think a colleague recently sent around a memo that used Garamond. Maybe it was Andrew.
Well, let's not shame him.
Well,
Wait, Andrew Ward?
Yeah.
No way.
Maybe not.
No way.
Maybe not.
He would
Okay.
never
Well,
do
in
that.
any case,
he seems like an equity guy or a
in any
century school
case,
book guy.
I think it's not as unreadable as you were saying. I think the italics are difficult, but
Yes. The italics are definitely challenging.
anyway. So on the footnote question,
Footnotes. People probably use them in the same way that people use weird fonts to fit things on a page to get around those limits. Imagine it's more likely to get struck for that reason.
Yeah, but in terms of like the hygiene of whether to use them or not, I think for me the lodestar is just readability, right? So when I first started practicing, I remember my first summary judgment brief I wrote. I was like, man, there's like so much evidence, there's all these facts, and I had seen other briefs where people use footnotes for the evidence, and so I had the facts section that was just like this one beautiful narrative of the facts, but it was all footnotes in terms of the evidence. I look back on that brief with a lot of shame because I think it looks both bad and also it's like unreadable because you need to know, if you're the judge, you need to know where the evidence is. And so I've kind of gotten to a place of if you can't work the cites to the record into the body of the facts, you just aren't writing it well. Like you need to write better. I also think that in terms of best practices for using footnotes, I try to limit it to one per page. Like if I feel like I need to use them in the brief for whatever reason, and I'm using more than one a page, I just think to myself, I'm not writing this as well as I could. Like that's one thing I think as a sort of rule of thumb that I bring into play. And also, I tend to use them for string cites. I don't really like string cites in the body. I think Sam is probably one of the people who pointed this out to me, that string cites in the body are not.
It's ugly.
It's ugly. It's not very readable. It's kind of distracting. And so I'll put them in footnotes, and that's kind of powerful. Yeah. But that's kind of all I have to say about them.
Do you guys generally agree with the if you have something important to say, put it in the body and not a footnote? Or do you think that there are times when footnotes is like a dagger that you can kind of slip in?
I don't like doing that.
Okay.
I don't like the footnote dagger. Just stab them in the front like a gentleman.
Okay.
Put it in the body text. Right.
I do think that. So the question is like, what counts as important? Like one thing I use footnotes for. I thought about this before today because I was like, what do I even use them for in practice? And I started looking back at briefs to see like how I use them. And one way I've noticed that I use them, I guess I haven't consciously thought about this until now, is to avoid to maybe make clear that I'm addressing a second order question that is kind of the meat of the case, but not conceding the first order question. So just to give you an example, like we've been talking about open fields today, like in our state court litigation, we're arguing about the state constitution. So I'll drop a footnote and say we don't concede the federal open fields doctrine is correct. And maybe here's a law review article explaining that reasoning that I agree with, but.
Did you write the law review article?
Well, I can now say that I have written the law review article, but in the example I'm referring to, I hadn't written it. But the point being, it's important for the court to know that if it wants to talk to us at argument or whatever about the federal open fields doctrine, happy to talk about it. I have views on that, but we're here to talk about the state constitution. That's the meat of the brief, but I don't concede anything, Your Honor.
Yeah.
I largely agree with that. So I think I use footnotes for two main things. One is string cites, as Josh pointed out. And two is just the occasional issue that I don't think really matters to what the court has to think about, but that I would imagine a reasonable judge or clerk reading the brief might pause and stumble over and be like, oh, well, what about that thing over there? Why are they not talking about that? Drop a very short footnote just being like, we know what we're doing. That this is the answer to the question you're probably thinking. It doesn't really matter. And that's 90% of the uses of footnotes in my mind. I will say one more thing on this because I was reading some of our colleagues had a crushing victory on the Fifth Circuit in the veterinarian speech case in September involving heroic Dr. Ron Hines, who's an elderly disabled veterinarian who has been fighting with the state of Texas for a decade or more now because they think he should not be able to email advice about pigeons in Iran and cats in Glasgow without physically going to Iran to inspect, the pigeons park or to Glasgow to inspect the cats, I don't know, litter box. I'm not a cat person. But in any event, the opinion is fantastic by Judge Willett.
Yes.
But as with so many Fifth Circuit opinions, virtually everything is footnoted. All the citations are footnoted. And just on Westlaw, trying to make sense of that, much less cite that in later briefs, I found to be extremely challenging, right? You're clicking on the little footnote superscript and going down and up and down. And it's not even like if you're looking at the actual PDF of the original slip opinion, it's one thing. You're it's all on the same page. You're just looking down. But when it's on Westlaw, all the footnotes are converted to endnotes. And
when you print off cases from Westlaw for argument prep or whatever, do you print them with the footnotes in line?
I do. Okay. I do, which is better. But if you're just skimming it on the screen, I don't think that's an option really.
No.
Yeah, it's tough because the endnotes make it basically unworkable. And I could imagine applying this rule to judges where it's if you don't want litigants to be using excessive footnotes, then, I'm sure that I assume that that the judges who don't like footnotes, I would assume that they probably don't heavily use footnotes themselves, but there are plenty of decisions where there are a ton of footnotes, and the Westlaw format makes it basically impossible because then also if you're reading them as endnotes, the majority's footnotes, the concurring opinions footnotes, the dissenting, it's all just kind of mixed together, the numbering restarts, but if it's an important point, you don't really get to read it in text. You have to scroll to the bottom, then back up to the top, and scroll to the bottom, and it's just very, very messy.
Justice Breyer, I think, historically never used footnotes. There may be, exceptions to that. Yeah, I guess he was big in appendices. He just assembled all the footnotes into a separate document and threw it at the end. Maybe.
I tend to like appendices. I've been using them more in my briefs. Just to I don't know. It depends exactly what you're using it for. But for me, if you have a compilation of facts that would be unruly to put in the body. But it stands for a simple proposition. Example, there were over 20 warrantless searches of this property. Right? You could just say that in the text of your statement of facts, but then you say, see Appendix A for a short description of every single warrantless entry and the record site for it and what they were looking for, et cetera, et cetera. That's not necessarily a dispositive issue. It doesn't really matter to the outcome of the case. All the court needs to know is 22 warrantless entries. Let's move on. I think it's useful to give the court the information if it wants to pour through it, but it's not really necessary in the body of the brief to have all that listed out in painstaking detail.
Yeah.
I agree. I've done that a couple of times as well for saying in the past year or so, this particular jurisdiction has filed this many forfeiture cases and this many were default judgments, and just throw it all in an addendum. And if they just want to trust us on the brief, great. If they want to double check, it's there.
Yeah, it's much cleaner to kind of separate it out and put it into its own document.
Yeah.
Yeah. All very interesting.
Would you like me to spill another glass of water to help you with your next transition?
So every transition, we're going to spill a different drink. Sam's going to spill a different drink. And what he's going to start doing is when he's done talking, he's just basically going to spill the drink to signal that he has nothing else to say. But Josh, I think you probably have something to say because you've been thinking about oral argument a lot recently. You just had an oral argument at the Pennsylvania Supreme Court. And I know that you've been thinking about oral argument prep and kind of the technological changes that have come with that and the changes that have happened over time. So curious about what you were thinking about with argument prep.
I guess I'll start by saying that I'm interested to hear how y'all prep for argument. I know Sam has his own kind of distinctive method, and I really wanted to bait him into talking about his method.
It doesn't require much baiting.
I know, John, you've had some experience with this too.
I actually just want to interrupt really quick because shortly after I came to IJ, I came right out of law school, and going to moots for people's oral arguments was very exciting because I'm seeing a bunch of experienced attorneys argue about all these interesting things. And one of my first moots that I went to, it might have been the first, was one of Sam's. And I'm sitting at this table, and Sam walks in, and he says something like, "This is in pretty rough shape, and so I'm gonna need y'all to be paid." It was probably one of the cleanest oral arguments I've ever heard, and so I just kind of got that if Sam says that he's not prepared for something, just don't trust him.
I think I just benefited from the fact that was the first moot you'd ever gone to. If you saw it right now, you'd be like, wow, yeah, that was pretty rough.
You had low expectations. You didn't know what you were hearing, John.
No, I think it was pretty good.
Okay, so I guess I'll just say a little bit about how I prep for oral argument these days. And it hasn't necessarily changed a ton since when I started, but I think I've gotten sort of better and more iterative at it over time. But maybe in broad strokes, I typically start by just rereading the briefs and looking at the parts of the record that seem like they're important. I might do that a couple of times. And then I go to, IJ has this room with a massive whiteboard on the wall. I just go to the room and I start to map out, if I'm the government, what are my strongest arguments, right? Because, the court's going to be concerned with those issues and want us to have responses to them. And, of course, we'll have talked about it in the briefs, but the oral argument's different, right? You're on your feet. You're trying to persuade them in as simple terms as possible. You don't have pages and pages. You have maybe a few sentences to get your point out before you're asked another question. So I'll kind of write out those best government arguments, and then I'll think through, what are the pivotal issues in the case that everything kind of turns on? And I'll do a little bit of a flow chart, and I'll just sort of say, how does this all feed into a few very basic ideas that we can point the court to that'll show that both their arguments are wrong and our arguments are persuasive, and they kind of get at the core concerns the court is likely to have. And typically that'll kind of center around a few very basic legal ideas and a few very basic facts. And if you can't distill your case to that, you're going to have a heck of a time at argument, and you don't want that. So once I've done that little mapping exercise, I then start to write some flashcards and write my outline for my argument and pull together some cheat sheets and just kind of pull my thoughts together. And I schedule a few I call them mini moots, right? They're just kind of informal moots with people who don't necessarily know a lot about the case and typically not the case team. Mm-hmm. And just start to get some reps in, start to get some questions down, maybe add those to my flashcard deck. So that's kind of the bones of it. But the thing that I think is the most helpful to me, setting all that aside and the mooting process aside, is I do a ton of just walking outside and talking to myself. And it's so funny because I was on a cruise with my wife last year, and I was getting ready for a North Carolina Supreme Court argument. And I was walking around the deck of the cruise ship because the argument was a week after the cruise ended. So I had to be preparing and had to keep my mind fresh. So I was doing laps on the deck of the cruise ship with my flashcards, and a lady stops me. It's not that big a ship. This lady stops me on my seventh lap of the deck, and she's like, "Sorry, but I just wanted to ask, are you prepping for a play, or are you on Broadway?"
Memorizing your lines.
I was like, "Man, my life is much less interesting than you're imagining," but something like that.
Yeah, different performance.
I basically told her, but it is kind of like that, right? Yeah. You're a lot of eyes are on you and you're trying to make sure that you're saying the right things at the right time in the right way with the right cadence. I mean, it's very difficult. The one last thing I'll kind of point out about my approach, at least, is that when I first started out, I did a lot of like watching other people argue to kind of see like what worked for me and what didn't. So I watched some Sam Gedge, I watched some Paul Sherman, watched some Jeff Rose.
The greats.
Don't try to imitate Jeff Rose. Yeah, and just kind of figure out what works for you. And then the thing that prompted me to raise this topic, John, was like ChatGPT and like where things might be headed. And we have a colleague, Rob Frommer, who told me that when he was prepping for a recent DC Circuit argument, he would like on the way to work, he fed the briefs to ChatGPT and then just said like, ChatGPT, ask me questions through the oral chat feature, and I'll just like read you out my responses, and it'll grade him and say like, here's how you did, here's how you could have done better. And it's sort of this way of like talking to a robot about your case. And like, I'm not sure how useful that is yet. I will tell you that I sent ChatGPT the introduction to my Pennsylvania argument to see like how it would grade on its like persuasiveness metric, however it decides that, right? Based on like current SCOTUS advocates. And it was like, this is really great. I was like, okay, I'm not changing this like this computer. One jot or tittle. I'm just keeping this as it is, and it never changed. So I'm not sure if that's necessarily like the golden compass, but it was something that worked for me.
Yeah, that's super interesting. The ChatGPT part of that, I mean, there's a lot there that's worth commenting on. The ChatGPT thing is interesting because I think it's ChatGPT and anything like it are different from the kinds of tools that we've had because it's not like you receive a book about oral argument, you read it and you learn it, and it's like, oh, that's all very interesting. I can kind of digest it. Now I have this tool because the AI tool is constantly like exponentially getting better and better and better at what it's doing. And so someone who maybe used it 6 months ago or a year ago, there's totally new models of it, and it is probably getting better at all of those things. I think the kinds of things especially that make it responsive to like briefing and having it generate questions. I mean, I think a large part of it is, have you educated it on the things that it needs to know to do that job well? And if you do that well, if you feed it the briefing, if you ask it to tell you what kind of questions what would you want to know to be able to answer this more fully?
Yeah.
It can tell you those things. And I mean, you can do some like fun, interesting, useful stuff with it. And like just messing around, like I have fed it a bunch of Supreme Court argument transcripts and opinions and stuff, and then given it some briefing, and then said, write a series of hypotheticals in like Justice Kagan's questioning style, and then give me like a spectrum from the easier ones towards the harder ones. You know, like when Justice Kagan is like trying to narrow down like what's your rule, that game with a bunch of hypos, and it can fire off very, very accurate versions of those that are actually get quite complicated.
Don't tell her that.
I know. So yeah, we irreplaceable. But it's pretty interesting what's getting to. And one question I had for both of you, and I'm still curious to hear Sam's secret argument prep style, but my experience is that you discover a lot about your arguments while you're preparing for oral argument, which is interesting because it's usually after you're done briefing.
Yeah.
And so you're kind of discovering ways that the arguments gel together as you're condensing and really sharpening this thing down to a point, almost in a way that you should go through that process like before your briefing, but it doesn't kind of happen until you're prepping for oral argument.
That's true. I mean, that happens every time. But it used to bother me. I was like, oh no, I missed something. And like, if you miss something big, like that actually probably is a problem.
Right.
But I've gotten more comfortable with it, right? Because yes, like you finished with your briefs, but you haven't finished with your advocacy, right? Like that's why you have an oral argument. It's not to, try to raise waived or forfeited arguments, but it's an opportunity to provide a different perspective, put a different spin on things. And I think almost every oral argument I'm prepping for, I kind of end up coming at it through a slightly different lens, and I spend like a few minutes kicking myself about not putting it in the brief, but then you just say it at the oral argument, and sometimes you win, sometimes you lose.
Yeah. So how do you prepare for oral argument?
Well, I feel like Josh has really like talked this up, but so I do a lot of what Josh described kind of as the early stage things. I really do spend a lot of time trying to figure out what the best arguments from the other side are. And I honestly, even during briefing, like when I'm filing a reply brief, I will spend sometimes days before I put pen to paper, like working on the table of contents. And
Same.
Yes, yeah, love tables of contents. And also like printing out the other side's brief and like trying to summarize it. But do it in the most objective, steel man way possible, just to like try to understand like the strongest form of their argument. Because I think it's really easy when you've been living with a case for years and you get their side's brief, you're just thinking, oh, it's these idiots saying this dumb stuff again. But the judges, of course, haven't been living with your case for years, and they don't know the other side are idiots. They don't think the other side are idiots. So
To be clear, opposing counsel are not always idiots.
Not always idiots. No, absolutely correct. But I do really just try to like scrub my brain of all my preconceptions as much as possible, and just kind of try to read it with fresh eyes and just home in on like, okay, if I'm coming to this case knowing nothing about it, and today is my first day on earth with this case, and I'm reading this brief, what's jumping out to me as the things that I'm concerned about? And a big part of oral argument prep is doing that as well. Now, the big thing that Josh, I know, gets a kick out of is what's called the circular outline, which I did not come up with. I saw it on X or Twitter, one of my non-logged in ventures into X.
It was a screenshot.
Yes. Someone printed it out and did it on like a manuscript format and mailed it to me. But no, it's just like what I've always found is that like writing an outline on a piece of paper in kind of like this linear fashion, I did that years ago, and I always found like it felt very static, and I wasn't feeling nimble when I was getting questions, because I'd be kind of just like working my way down a page, and I get a question, I'd be like, okay, where back on this page, where was I? And
Right,
like,
there's like a flow chart and someone interrupted
exactly, and it just feels very kind of brittle. But what this guy has described as a circular outline is just basically what it sounds like, right? Instead of it just being like this linear thing, you kind of like have this kind of circle with your main points, like one or two main points and a couple of sub points, and you just kind of like work your way around the circle. And if you get interrupted, ideally, you're just kind of like, you answer the question and you just keep going around the circle, around and around and around, rather than trying to like, oh, I missed this thing back there. It's hard to describe. I have a couple of them in my office from previous arguments. And in reality, like when it comes down to it, and I'm actually standing at the lectern, not a podium, of course, Josh, standing at the lectern, I think in reality, like I'm not actually like executing this kind of like circular outline maneuver. But for me, just the practice of doing it and putting it down on paper, and oftentimes doing it a few different times as I like, think of better ways to do it. Just like that practice really, in my mind, makes it all kind of fit together in a way that just writing it all out on one piece of paper or typing it all out, because I handwrite the circular outline. Has never really done that.
It's sort of like law school, though. I mean, like when you have an exam and you're writing your outline for the exam, like for me at least, I was learning a lot of the content, or at least confirming my knowledge of it or solidifying my knowledge as I was writing the outline. Right. You're putting things in your own words and you're synthesizing and integrating concepts. And, if you're at the argument, you're not typically staring at the page much or I mean, there might be like a quote you're reading or something like that, but if it's like super good. But generally speaking, you're just having a conversation with the court at that point. You've done your prep. And so for me, the process of like making the cheat sheets, making the outline, whether it's circular or linear, is one that gets me mentally ready and kind of gives me I start to grok the case, right? Just kind of understand it intuitively.
Right.
And once you've done that, you're in the right place for the actual day of the argument.
Yeah, what you were saying about walking around and talking, I feel like that's like a necessity for me as I was like prepping for stuff. Yeah. And it does make you look like a crazy person, but I don't know any other way to it's basically another version of you're writing it down by hand or you're drawing something. Like there needs to be some kind of point at which the information and the ideas are integrated into you, and then it becomes intuitive.
And this is like, and I'm no master, right? But I will tell you that one thing I found useful is that at some point go on the walk and shed the flashcards, shed the written materials, and just like you've practiced the questions and the answers, and just go walk for a few miles and just talk about the case and like ask yourself questions that come to mind. Act as if you're speaking to somebody who knows nothing about it, and just kind of do a little bit of free-flowing thought and just get yourself conversant in the topics, because on the day of the argument, you want to be conversational about it. You don't want to be reciting some script that you've memorized.
Right.
Josh also said self-deprecatingly that he's not a master, but obviously we both saw his Pennsylvania Supreme Court argument a few weeks ago. The world, I'm sure, saw
We'll
it.
link it in the show notes.
It was really a phenomenal performance.
It actually was wonderful.
Yeah.
Yeah, you can see the fruits of it. So we like opposing views on this podcast, and we like dissenting opinions. But I wondered what you guys think about dissenting opinions, because I feel like my views on this have changed since law school. When I was in law school, I remember reading some fiery dissenting opinion and thinking that it was often just like a great example of a justice who is being heroic in the face of some really dumb thing happening. But of course, if you agree with the majority, it's just like it's someone who is wrong and felt very strongly about it. And it feels like dissenting opinions are just used for so many different things. Like you have dissenting opinions, and I'm thinking here more about like courts of last resort, like state Supreme Courts or the U.S. Supreme Court, where dissenting opinions probably do play a different role than some kind of lower court. But I mean, you have dissenting opinions that seem like they are maybe on one end of the spectrum kind of performative. I really disagree with this. I want people to know it. You have dissenting opinions that are something like maybe strategic signaling, where you're either telling litigants or other justices, like, this is what I think, I'm staking out a position here. And then you have probably this more, idealistic view of what a dissenting opinion do, which is, we're on this path, we're taking a route that I don't agree with, and I'm going to put the post here so that one day either this court or the public will look back and see, like, I think that we're about to take a really wrong turn, and so we can return to this decision at some point and correct it. And I'm wondering if you think if that's accurate, that dissenting opinions are kind of used for a spectrum of things. And also, what do you think the optimal use of dissenting opinions
I'm glad you drew the divide between the, descriptive and normative here, because I think there's a lot of things they are used for,
yeah,
and maybe a narrower set of things they should be used for.
Mm-hmm.
I don't have all of that figured out, but I do think that in terms of what they are used for, I mean, there's a lot of the things you highlighted, which I think are laudable in many contexts. But there's also just like venting,
mm-hmm.
right? Like kind of screaming into the wind a little bit about a decision that the dissenter thinks is egregiously wrong in whatever way. Signaling, which I think is maybe like a less laudable use, somebody signaling moral preferences about what the court is doing. I think that's probably less appropriate than just saying the court got the law wrong, right? And then there's sort of like the auditioning aspect to it, where, I mean, who knows, I'm not going to point fingers, but there's certainly the idea that there are certain circuit court judges maybe, or certain state Supreme Court judges who write their opinions in ways that maybe they're auditioning for a higher level of court. I mean, I say maybe because I'm not going to call anybody out, but that seems to be happening a little bit, at least in my view, and that doesn't seem like a good thing, generally speaking. But in terms of the normative and what they should be used for, I think generally speaking, saying what the law is, taking a stand when the court gets something egregiously wrong. I do think that dissenting every time you disagree with the majority and writing in a separate opinion for that is probably not the best use of your time as a justice or a higher level court. I think that if you're picking your battles, pick the ones that are most consequential, and like these kind of pivot points in history you're talking about are really good opportunities to write those big dissents. But I don't think every time you just write, I dissent. Or
when's
I
the last
concur.
time that's happened where a justice...
It seems to be pretty common on the court right now for
Yeah.
everybody to write their own opinions, and it doesn't seem like a good
And
trend.
historically, you see that where you'll just see dissent without an opinion.
I think that's right. Yeah, I mean, like it was relatively common, I think. I might be misremembering, but I think, was it like Myers or Pierce versus Society of Sisters? And it may be neither of those, but I feel like in the 1920s, you'd see like just the two-word dissents. It's, I don't know, a little bit refreshing. It's like, I'm not going to go on record. I mean, I have to go on record not agreeing with this. I didn't vote for it, but...
Yeah, I think Buck versus Bell, there's a I dissent, but it's just
that one might have
it
warranted.
would have been nice to maybe have an opinion there. Yeah,
yeah. I mean, like I'm kind of agnostic about dissents. I guess I sure like nothing that either of you guys have said seems wrong. I when I find them useful, I'm happy that they're out there. I don't think they ever really make my life more difficult. I do like every once in a while, I find that Supreme Court dissents can be useful when I like the majority opinion and I want to kind of like read it in a certain way, and the dissent in like trying to paint how bad the majority opinion is basically says like, read taken to its logical conclusion, this means X. It's like, well, indeed it does. That seems great. But yeah, I mean, like certainly when it comes to lower courts, like to the extent that dissenting signals that there's a judge who's really engaged in the case and interested, like I think that's great. The more that judges are interested in my case, interested enough to dissent or write separately, like I think that's fantastic. I think there are bigger problems out there in judicial decision making than judges caring too much about cases.
I think one thing that I'm not sure I have strong opinions on, but that seems like a fertile topic for discussion, is justices writing concurrence or dissents that purport to frame what the majority holds. Because you then see later opinions, like there was the famous Chief Justice Roberts line about how we don't typically take our guidance on what the majority means from the dissent, or whatever that phrasing was. And I don't know. That's sort of a point well taken. But I'm not sure what the appropriate level of course, if you're writing a dissent, you have to at least say what you think the court is holding that you're then responding to, right? So I don't know. I think there's something to the idea of framing the majority opinion, but if you're doing it in a way that is inconsistent with what the court is holding, that's its own problem, right?
Right. Yeah. I mean, the whole point is if you're in the dissent, you couldn't convince enough justices that your framing was correct. But it seems like if you're the fifth vote and you're writing a concurring opinion, you have a little bit more, there's something there where you can say, this is my understanding. And even if the other four don't agree with you, that fifth person's understanding is going to matter.
I mean, this can spin out of control too. I mean, you have Justice Harlan's famous concurrence in the Katz case in the 1960s saying, I concur on the understanding that the rule the majority announces, and then he announces his two-part reasonable expectation of privacy test that becomes the test, right? So clearly the majority hadn't articulated that test, but of course he joined on the understanding that that was the rule that was being adopted.
Yep. Yeah, another example that is Lowe versus SEC, Justice White's opinion that basically invents what will later become the professional speech doctrine. And I guess you could say in those situations, the majority left open the fact that a concurring opinion is going to invent the test because you didn't give enough guidance or respond to the concurring opinion. But yeah, go ahead.
I'm sorry. Sam, did you have anything to say on that last topic I raised before I raise another?
I don't think so.
Okay, I just wanted to also the issue of justices writing to forecast how the rule of law adopted in the opinion will affect future cases. I'm uncertain how I feel about that. It's been common in recent years for concurring justices to write, our opinion should not be construed to do X or to mean Y. And it's like, well, you're concurring, so I don't really know what to make of that, right? And certainly someone will cite that in a future filing in the court to argue one way or the other, but is that really going to matter that much?
Right. Attempting to limit the majority.
Right.
Yeah.
Yeah.
Or to forecast how it's going to impact future litigation.
Yeah. Also, the majority has, if they've adopted a principle, and that principle is now a thing that's going to do the thing that it does.
Yeah.
Yeah. Very interesting. Okay. So we'll end with something that our listeners really want to hear about, which is one legal thing and one non-legal thing that has been enriching your lives.
I guess I'll start because Sam looks Sam looks despondent.
Sam is enriched by so many things that he's having a hard time picking one of them.
You can just fall back on the fact that you're rereading Master and Commander for the 20th time.
Oh, that's true. I think I did that last time.
Well, I'll give you.
That's
I'll give you a bit of.
That's the running. That'll be the thing.
I'll give you a bit of runway then.
Which book you're enjoying?
Yeah. So, non-legal or legal first. I'll start with.
You can do it. Yeah,
I'll start with the non-legal. I mean, this might be a little hot button to mention, but I just finished Douglas Murray's On Democracies and Death Cults. And just the original reporting in that book alone is excellent. He went to Israel right after the October 7th attacks and did a lot of frontline reporting about what he saw. He went to the site of the Nova Festival. He visited the front lines of where the fighting was happening and was traveling with military troops and stuff like that. I mean, it was just the quality of the actual journalism there was, for nothing else, that's a reason to read the book, to get a firsthand account of what's happening on the ground. So that was pretty enriching. And then a legal thing, there was a reference earlier to Judge Wilkinson's opinion in the Abrego Garcia case. I can't claim to be following every step in that dispute, but I will say that I think his opinion there, if you haven't read it, is worth a read, if only because it's a good example of how diplomatically a court could and should approach these issues. I mean, the court at the very end of the opinion basically just says, like, there's a lot of tension between the executive branch and the judiciary right now. It seems like that's avoidable. Like, it doesn't have to come to a big collision. And like, we have a lot of faith in our brethren in the executive, is the language he used, that, we can veer off this course we're on and come to an amicable solution where we both respect each other as co-equal branches of the federal government. And I think that was a good sentiment. And he took the temperature down a bit at the end, and I really appreciated that.
He's trying to prevent the bar fight. Hey, dude, we're good. We don't need to.
Yeah, no, I thought it was, whatever you think of these issues as a political matter, I think it's the right way. We should be bringing the temperature down, not up, in these kind of, fractious disputes between the branches.
That was very insightful. I think my legal one will also have some similarity to Josh's, and not only because I've been struggling to come up with any answers, but tackling the non-legal one first. You mentioned Master and Commander.
I think Josh did, but I
you chuckled.
It regularly.
You chuckled when Josh mentioned Master and Commander. So I will confess something that's a little bit embarrassing. I haven't been reading Master and Commander recently because my wife and I entered into this devil's compact where I would read some books of her choosing at first with what I thought was the understanding that she would, then read a book of my choosing.
That is bold.
Yes. Well, so I'm now in book 5 of this 5-book, it's described as a romantasy series. I
can't wait to hear the title.
I honestly
Court of?
Yeah. There's a court of something. Yeah.
Thorns.
Yes. Wait, do you guys know it? Because I think
they're very popular.
Oh, okay, great. Yeah,
so it's from Book Talk.
I have no idea. I've just been reading the books. There's also like
I hear they're spicy.
Yeah, they're a little bit spicy. Yeah, but there's an acronym as well. In any event, I stand by them. They're actually decent books. But now that I'm in book 5, it's become increasingly clear to me that, in fact, my wife is not going to hold up her end of the bargain and is not going to read any Master and Commander books.
That was the deal? It was one Master and Commander for one?
Well, it was kind of like, I'll
where
read
it was
these.
Going.
Yeah, but then every time I was like, okay, like she's like, how are you liking book 3? I'm like, well, it's great, and I'm really excited for you to read the first Master and Commander. And she's like, no.
Also, those are many hundreds of pages, the books that you're reading for her.
Yes. I mean, now they're for me. Like, I'm very invested. But
suckered into a book deal.
Yeah. Well, I stand by it. Like, I have no regrets. But I will say that a Master and Commander book is like 400 pages long, and this is like 3,500 pages. So I think it would have been a fair trade. But
do you talk about the books after you read them? You like book club it?
Not really. Like every once in a while, she'll be like, "Where are you at?" And then I kind of tell her. But
she's like, "Have you got to the scene yet?" And you're like, "No, I haven't gotten there yet, but I can't wait."
You sound like someone who might be secretly reading these yourself, Josh. I don't know. And you should. They're excellent. They're excellent works of literature. But the other non-legal thing, which I have enjoyed, non-shamefacedly, is this Netflix show called The Gattopardo. And I don't know if I'm pronouncing it correctly. It's leopard in Italian. And it's this historical miniseries about Sicily in the late 1850s, early 1860s. It's really, really excellent. It's in Italian.
Come on. Yeah. Now I don't want to watch it.
But there are, you'll be happy to hear subtitles. Okay. I just think it's great. I think Netflix should make more just random things about 1860s Italy, frankly.
A little vignette.
Yeah.
What is it? So what's the show about?
So it's just about this very kind of rich, declining Bourbon aristocratic family outside of Palermo.
Okay.
And how they adjust to the replacement of the Bourbon monarchy with kind of the Italian Republic and Garibaldi and this whole like upstart surge of new like bureaucrats and government officials. It's actually very good. I do recommend it. As for law, the thing that I was kind of grasping towards, which I think is similar to Josh's, is I have been following a bit all of like the very expedited Enemy Aliens Act and Abrego Garcia litigation, and what's just impressed me is just like the challenge that these plaintiffs' lawyers are. They're just like juggling so many balls. The deck is so stacked against them. They're like filing emergency motions in Texas and New York and D.C. and the U.S. Supreme Court all in the same day. day in, day out, and it feels like week in, week out, month in, month out, and just kind of the stamina that must take is really impressive. And so that's my take.
Yeah, no, that's definitely true. I heard someone online complaining that the court had done something on a Saturday.
I think that might have been Justice Alito in his dissent.
Oh, maybe.
Or was that he was complaining that they did something at midnight?
At midnight, yeah.
At midnight, well, it is busy times, but yeah, it is exhausting to even follow it. I know Josh was saying it's difficult to follow it, and it is. There's so much going on, and there are different cases and different issues, different courts, but it's all very fast moving. My non-legal thing is I just finished the book Pale Fire by Nabokov. It is I don't know if either of you know anything about it. I did not know anything about it before I started reading it. It is, I think it was published in 1962, and it's a very interesting book. I highly recommend it. I would say it's not a book disguised as a book, and what I mean by that is the foreword, it kind of has 4 parts. As a foreword, it has a long poem, and by long, it's like 20, 30 pages of the entire book. And then there's a commentary, which is like 180 pages. It's commentary on the poem. And then there's an index at the end. The foreword and the commentary and the index are compiled by someone who is a colleague of the person who wrote the poem. That's like the fiction. So the foreword is fiction, the commentary is fiction, the index is fiction. And so the poem is written by this guy named John Shade, he's a professor, and one of his colleagues is writing the foreword and doing the commentary. Totally unreliable narrator. And so you have this poem that this guy is kind of writing what he thinks the poem is about, and a lot of it just sounds like nonsense, but it's not. Nothing that I say about the book is going to make it sound coherent or interesting, but it is both of those things. So
you've got me really intrigued.
Yeah, I'm trying. It's more. I think the thing that's interesting about the book is it's less of a book and kind of a puzzle. So the poem references things that are kind of wrapped up in the commentary, and then there's an index. Because the idea of the poem is that the guy wrote it in the last days of his life on index cards, and they took all these cards and he gave them to this person and died. And the person has put them together and then is trying to comment on them.
Is it written in that like typical mid-century, like kind of terse, clear prose that I'm so prone to?
I would say he definitely has his own writing style. There's parts of it that, especially the commentary, that are actually more like Ulysses' stream of conscience. Like that part of it is difficult. The poem is actually just a very good poem. It's not like in a particular style, but it's very good. It's one of those books that you finish and you realize that you probably like scratched the surface on a book that has a lot more going on, and people are probably experts on it, have been studying it for years. But it was
much like Master and Commander.
Much like Master and Commander. I bet that you could do a podcast series on Master and Commander. Have you thought about this?
I haven't, because there already is the definitive podcast series. It's called The Lubber's Hole.
Okay. You think that it's worthy?
I mean, I don't think. Yes,
I know.
Yeah. I mean,
okay.
So I can't say I've listened to all of them, but it's these 2 guys who spend upwards of like 10 episodes on each book.
Okay.
And it's just like, I don't think there's no point in anyone.
What would you do?
Yeah.
Okay.
Like,
Well, that's good to hear that there's people who love it enough that I still imagine that you could do a podcast if you wanted to.
I don't know. It would just feel redundant.
You could be a guest on the show.
If only. Yeah.
My legal thing is not really a topic, but I have been kind of listening through the last this term of oral arguments that I hadn't got to as they were kind of coming out. And that's been great. And one thing I've been trying to do, which I tried to do during law school, and then, for the first several years of work, I was more focused on things that I actually cared about substantively, because if I'm listening to like an ERISA case, no insult to anybody who's an ERISA attorney, but, like my eyes kind of glaze over. And I think one thing that I've been doing is listening to all of the oral arguments, and even if I'm not super interested in the questions presented, just kind of thinking about what the justices are thinking and how they interact with each other. Because, like even if it's a case that's not about a substantive area, how they decide to interpret something or how they resolve the issue does like often tell you quite a bit about what they think in general. So I've been enjoying that.
Can I sign us off by reading a quote from the opinion that I mentioned?
Oh, please do.
I think it's a nice way to end things. So this is what Judge Wilkinson writes at the end. It is, as we have noted, all too possible to see in this case an incipient crisis, but it may well present an opportunity as well. We yet cling to the hope that it is not naive to believe our good brethren in the executive branch perceive the rule of law as vital to the American ethos. This case presents their unique chance to vindicate that value and to summon the best that's within us while there's still time.
Wonderful words. All right. Well, thank you very much for being on. Thank you for our listeners, and tune into our next episode. And until then, that's just like your unpublished opinion, man.
I'm gonna do like a Chinaman, go and get some hops, get myself a gun, and shoot myself.